Got a question asking if you have to provide relocation fees to a tenant that is destroying the property, why, and if they're not following the lease, is it mandatory to provide relocation assistance? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos here. Now, I think this comment or this question came off the videos we've been doing about terminating the tenancy for substantial renovations under California's Tenants Protection Act of 2019. As y'all may recall, that is a no-fault, just cause type of ground to terminate a tenancy for, meaning the tenant has not done anything wrong to cause the landlord to issue that type of termination of tenancy. All right. So under the Tenants Protection Act, without regards, the law says basically without regards to the tenant's income and so forth, a landlord has to provide at least 1 month's worth of move-out assistance to effectuate that no-fault just cause eviction. Okay, and you have to put in the notice how you're going to provide it to the tenant, such as if you're going to waive the last month's worth of rent, or if you're going to provide a cash payment within 15 days of issuing the notice. Okay. As to that type of termination of tenancy, the law prescribes that the landlord just provide the move-out assistance. Okay, there's no ifs, ands, or buts about that. Whether the tenant has paid their rent, destroyed the property, or whatnot, if a landlord's issuing a termination of tenancy for no fault, just cause reasons, such as a substantial renovation, you just got to provide the assistance. That's what the law says. Now, let's turn the question around. Let's dig a little deeper here. Okay, so this landlord is saying here that do you have to provide or rent relocation assistance for like an at-fault just cause eviction under California's Tenants Protection Act? The answer is no. Okay, so for fault eviction, like the tenant is committing waste or is destroying the property in violation of the lease and common sense, that is generally an at-fault just cause eviction. Okay, that would be committing waste pursuant to the Code of Civil Procedure, Section 1161, Subdivision 4, or if they're caught, they might be. And if you're destroying the place, you're probably violating some type of material lease term, like you're properly use the premises and keeping it in a clean and sanitary manner. Okay. Those types of evictions are not subject to the no fault just cause like relocation assistance provision. Okay, and I know I'm going to get a question on here. What if I'm doing a substantial renovation because the tenant was destructive and destroyed the property? Okay, well, you would still have to provide relocation assistance for that no fault just cause reason. Okay, because that's what the law says. It's mandatory, okay, to issue that no fault just cause termination of tenancy. When we're dealing with like terminations of tenancies, things can get very nuanced and so forth. One thing that I tell landlords to consider is when you're doing a no fault just cause eviction, the only things that you have to prove to a court are that you've complied with all elements of the law and that you're doing it in good faith. Okay, basically you're not sending a notice, hey, I'm going to be renovating the property, and you have no intent to do that. Okay, there are big consequences under the Tenants Protection Act for landlords that falsify or mislead their tenants on what type of termination of tenancy it is. Okay, so they just added some provisions last year to the Tenants Protection Act, for attorneys' fees and so forth. For any non-compliance with the Tenants Protection Act renders the termination notice void, for example. So you got to be careful that you make sure that you can meet those elements of the law. I could see a landlord not doing like a waste eviction or an eviction for like violated material term, a lease term, for example, because they may not have the evidence to prove that in court, or it may be cumbersome to prove. So instead, they may have an option to terminate the tenancy for a no-fault reason. Okay, it affects the landlord's burden of proof if the case is contested in court, possibly. So Landlords, I always tell folks, when you're considering terminating a tenancy nowadays, because you may not be exempt from the Tenants Protection Act, you might have to comply with the Tenants Protection Act or local laws here. You might want to consult with legal counsel before you even do consider issuing any type of termination notice, because if you issue the termination notice wrong, on the wrong grounds, you may have evidentiary issues, you may have procedural issues, such as you didn't put the right disclosures in your termination notice, rendering it void, and you're gonna have to start the process over again in court, or you have some guy like me tell you, hey, you're gonna have to redo the notice because it's not in the proper legal fashion. So if you're contemplating terminating a tenancy, you're in the Northern California area, feel free to reach out. We're here to help out. You can hit my profile down below, and I'll go to our website, and you can book a free case review there. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.